So, what are the situations under which a principal agent relationship or agency arises? Okay. To start with, you can have an express agreement between the parties. The principal expresses the desire for the agent to act on his or her behalf, and the agent accepts that and proceeds to act on his or her behalf. That's an express agency. It can be in writing or verbal, but nonetheless, the intent of the principal to have the agent act on their behalf and the intent of the agent to act on the behalf of the principal is expressed. All right. Now, what happens if you don't have this level of expression, this communication between the parties? Then an agency can still be implied from the facts of the situation. If one party undertakes to act on behalf of the principal and there's evidence that the principal intended for that agent to act on their behalf, then the court can find, based upon the facts of the circumstances, that an agency relationship is implied here. But again, the court will look for some level of intent on the part of the principal for the agent to act on their behalf and some intent from the agent to act on behalf of the principal. Okay. Again, but that would be implied from the facts. Next, ratification. If the agent or the potential agent does something acting what would seem to be on behalf of the principal or would generate some benefit or obligation for the principal, and the principal accepts that, in that situation, I am ratifying your action. I'm, in effect, making you an agent after the fact. Next would be by estoppel. It's a fairness doctrine. If a party acts on behalf of another party with some third party, if that third party reasonably believed that the proposed agent was acting on behalf of a principal and they acted to their detriment, they undertook something that if the agency relationship does not exist, that it's not true, that it will be to their harm or detriment. If the principal in some way was the cause of this reliance, of this reasonable belief of this third party that the agent was acting on the principal's behalf, in that situation, would give rise to estoppel. The court would say, okay, principal, it was your fault that this third party reasonably believed this agent was acting on your behalf. Even though the agent might not have been, there was no express or implied agency, we're going to impute an agency relationship here. Okay. Again, the principal will be bound by the actions of the agent. And then lastly, an agency out of necessity. All right. The principal themselves cannot respond, cannot act on their own behalf, and a third party undertakes to act on behalf of the principal. Because the principal would need to act in this situation, there's no opportunity or option for the principal to act, and the agent undertakes some level of reasonable activity on their behalf.